Right, let the others join in. Until that time, we are now reaching towards the end of the lecture series insofar as at least I'm concerned. And most probably you would have um, maybe one or two lectures, but don't hold me on to that. Presuming, if possible, I would try to conclude the two topics that I intended to do today. If not, we will have to continue next week. So, if you have any questions on whatever that we discussed, please do ask me. What I intend to do, as I informed you last week, is to cover the areas on debt recovery laws, mainly Act number 2 of 1990, right? Act number 2 of 1990 and Act number 4 of 1990. Remember these phrases, these matters that I'm mentioning, because when I mention Act number 2 of 1990, you, by the end of this, or at least you should know what we mean by Act number, what do you call, 2 of 1990. Act number 2 of 1990 basically covers the Debt Recovery Special Provisions Act, right? Debt Recovery Special Provisions Act. I will just, for the easiness of understanding, I will. This act was mainly amended by Act number 9 of 1990. Right? There were quite what do you call, significant changes that was brought about with regard to this particular act in Act number in the amending act. Right? What you need to, I will just show you the original act on the screen now. This is quite important, right? This is quite important. And again, these acts, links to these acts are freely available in the internet. Any act for that matter is available in www.documents.gov.lk. This website. You can find whatever the acts that you are looking for in this particular piece of website. And this is an official site. Before this, so I hope you all are getting your notes down when we are going through the process under this, right? So coming back to the Debt Recovery Special Provisions Act. As you know, when example, there is a bank and a customer, the bank has lent some amount of money to that particular customer who, right, kept on repaying the amount. And if they do, if and he suddenly started defaulting on the repayments, what do the bank do? The bank has to go through the normal recovery process. What is the normal recovery process? First, the bank will be what do you call, maybe rather calling the customer and reminding him about uh, the installment repayments that he is lagging back. And if he doesn't respond, the bank will send a letter through the bank. Maybe termination of the facility, termination of the uh, credit facility, right? Once that is sent, once that is sent, if the customer still doesn't respond to this, what the bank will do is through their lawyers, the bank will send the customer what you call a letter of demand. අපි සිංහලෙන් කියනවා එන්තර වාසිය කියලා, right? Letter of demand, demanding the sum amount of money which the customer has defaulted on the loan plus interest plus any other bank charges, right? And ideally, after that happens, the customer will have to respond to the letter of demand or might even decide in not responding. However, if there is no feedback from the customer, the bank will have to file action to recover that some amount of money lent as the loan to the customer. So how does the bank do that? Bank has to, through their lawyers, what the bank will file would be a plaint, which would include the whole claim of the bank, right? This is a normal money recovery process in the relevant court in which this agreement is entered into. I'm just putting this in the very, what you call the most simplest of form, right? So once the plaint is filed, summons will be issued to the customer through the court. So insofar as this is concerned, I would now address the customer as the borrower, right? Issued to the borrower through court, right? Once the customer receives summons, or rather the borrower receives summons, the borrower through his registered attorney would appear and file their proxies and file their answer to this plaint. Plaint is basically the claim of the bank with regard to the monies that they are alleging to be owed by the customer. So upon this plaint, the customer or the borrower would file what you call an answer. The borrower answer to the plaint. Now I'm just taking you through the whole money recovery process at the outset, right? Once that is filed, and there are certain other procedural elements that needs to be fulfilled, like the pre-trial steps and so on and so forth, the bank will lead evidence with regard to the loan agreements and the fact that the loan was disbursed to the customer's account, and customer started repaying, and then he defaulted on repayment of the loan, and thereafter didn't pay, and the loan agreement was terminated, and thereafter a letter of termination was sent, and a letter of demand was sent, and no response, and this amount is due and payable by the customer. And the customer, if he has a genuine what you call a defense, he would, of course, again, he would lead his part of the story, his side of the story as to what happened, whether he's disputing anything what the bank is saying or not. So depending on the matters that is brought before the court will then make an order in favor of the party who has proved their case, right? So this is the normal process. This is the normal money recovery process, right, at the outset. Keep in mind, when the summons are issued to the borrower, we call, at that point, the borrower become the defendant in the case. So the party filing the money recovery case is called the plaintiff. The party against whom the money recovery case is filed is called the defendant. right? Now, the defendant here has a right, as of a right, can come to court and file his answer, right? This is one of the main reasons how the normal process, you call this the regular process, differs from the Debt Recovery Act, or Act number 2 of 1990. If you see the caption to this Debt Recovery Act, why is it? You can't see everything, no, for some reason. Wait. Right. I am going to take you through certain important provisions of this Debt Recovery Act, right? Right, we are going to discuss these certain provisions. Okay, just settle with this. This, as per the long title, it says this is an act to provide for the regulation of the procedure relating to the debt recovery by lending institutions, matters connected therewith and incidental thereto. So, what I spoke up to now is on the regular procedure, I told you, right? The regular procedure. But here they are talking about the another procedure relating to recovery of debt, right? Now, you would see, I hope you all have your Debt Recovery Act with you, right? This is utmost important, my dear students, for you to know what we are talking about, right? And understand this, each and every single provision of this are equally important, right? Because all of them are there for a particular reason. Now, Section 2 of the Debt Recovery Act, as it was here, it was amended. Keep this in mind, you may take down your notes by the Printing Act number 9 of 1994. Let's see if I can pull out the Amendment Act. It was there somewhere. Yeah, you go. Right. Section 2 of the Debt Recovery Act is now amended. The original Section 2 is amended by like this. So here is the original one, a lending institution, it goes like this. And here, let's see how it is amended. By the repeal of subsection 2 of that subsection, right? So subsection 1 is intact. Subsection 1 is intact. It wasn't amended. This subsection 2 is intact. Amended. What the subsection 1 says? A lending institution, it defines what a lending institution is. Also, may subject to the provisions of subsection 2 recovered it. I beg your pardon, it's not definition of the institution. It's referring to an institution, lending institution. Provisions of subsection 2 recover debt due to that particular institution by an action instituted in terms of this act in the district court in the local limits of jurisdiction. where the defendant resides, defendant is the borrower, where the course of action arises. Where did they enter into the agreement? Or where did the defendant default in payments? Then thirdly, where the contract was sought to be entered. Now, I want to mention when there are money recovery cases,
Sir,
the monetary value of the particular case, you have to file the action in the relevant court. For all commercial matters, right? Disputes arising of commercial matters where the value of the case is over 25 million, you cannot go to the district court, relevant district court. You have to go to the commercial high court if it is in Colombo.
sir,
Right? For A, B, and C, despite that, if it is in Colombo, not despite that, if it is in Colombo, you have to go to commercial high court and district court. However, you would see, note this down, under the Debt Recovery Act, irrespective of the amount
excuse me, sir.
of the loan or the some amount disputed or the case value, whether it's 5 million, 10 million, 25 million, 30 million, 50 million, if you are instituting action under the debt recovery law, you have to institute it or file the action in the district court, not the commercial high court. Right? Then, as I told you, section 2 is amended. Right? You might think for a moment that this whole
Sir,
lesson on debt recovery is quite dry. You would feel like that if you know how interesting this is and how efficient this method of recovery of money.
Excuse me, sir.
When you know the whole requirements and ingredients, because it's very
Excuse me, sir.
important. Right? Now, subsection 2, the new section goes like this: no action shall be instituted by an institution in terms of procedure data. Like that, to the recovery of any debt where somebody to be before is less than 150,000 rupees. What is the second condition? If the now this is obsolete now. Anyway, no one can file action if no one can file action. No one can go and directly file action. So if the sum amount is 150,000 or low, if the borrowed amount or whatever the defaulted amount or the value of the case is less than 150,000, you can't go under the recovery. Right? Right. Then, behind the amending act, there is the section 4 of the principle. Now, let's see what section 3 says. So, an action under this actually instituted by presenting a plaint in the form in civil procedure code. So, you don't have to worry much about it for the moment. Now, this section 4 is amended by the amending act. Let's see what section 4 says. This is absolutely important. I told you in regular action, you will file a plaint. Right? You will file a plaint and summons will be issued. See what extra things that you need to see if you are or the bank is filing action under the Recovery Act number 2 of 1990. The institution or the bank suing shall on presenting the plaint. So similar to the regular procedure, here also there is a plaint, right? And not just the plaint, it's not enough. File with the plaint and affidavit, given Parat. To the effect that the sum claimed is lawfully due to the institution from the defendant. So this particular affidavit they need to file with the plaint should mention the sum amount that the bank is stating is due and payable by the borrower, right? Is lawfully due by the borrower. Then a draft decree NISI. In Sinhala, a draft decree NISI is known as Tindu Prakashya Ketumpata. So order is delivered and the decree order is delivered and the decree is delivered. It's the written order. The decree is the written order. Then the requisite stamps for the decree NISI, right? NISI Ajnave Adala Mudra right? The draft decree NISI. NISI Tindu Prakashya Ketumpata Sahayada Adala Mudra. The requisite stamps for the decree NISI. And for the service thereof and shall in addition. Filing code, right? So not only that, in addition, filing code. Such number of copies of the claim is for affidavit, instrument, agreement, or document sued upon. So it is not sufficient to mention or have only the claim. That if the let's say if it's a what do you call amount that is due and payable on a check that you get, so that right, that is a, and that it got written. That is an instrument under this, right? Instrument, agreement or document sued upon. What is the agreement? The loan agreement that you entered with the customer for the borrower. Sued upon or relied on the institution as is equal to the number of defendants in the action. If there are one defendants, one set of those. There are three defendants, three sets of those. That should be five. If you don't have a five, then your action is futile or it will fail, right? It is not a valid action under the Recovery Act. Okay. If you haven't, you don't understand anything, you can of course ask me. Subsection 2 of this section, right? We are talking about the just spoke about subsection 1 of section 4. Now we are talking about subsection 2, right? Here they are saying amending, substituting for the word some mention in the plane of the word some prayed for in the plane. Right? Not very policy, quite technical. Yeah, don't worry about those. Right. Right. Now, subsection 4 is again repeal. Repeal means you delete it. And this new subsection is fine. Here again is an important provision. The affidavit to be filed. You remember we said that subsection 1 of the section 4, you need to file an affidavit. The affidavit to be filed, not anyone can file an affidavit. It should be the principal of the bank who should file the affidavit. In personal knowledge of the facts of the court of action, such question in the affidavit. Swear that he deposits from his own personal knowledge the matters that is mentioned in the claim. Right? Right. Now, this section 5 of the original act also amended. Right? How is it amended? It is substituted in this section, in section 5, subsection 1. Decree NISI shall decree NISI Ajna, right, shall subject to the provisions of section 5b be ordinarily served on the defendant by registered post. So you file it in the court, and this decree NISI. When in the regular action, you file summons. You send summons to the defendant. Here you don't send summons. You send the decree NISI. It's different. We'll see how is it different. The effect of the difference. Right? We'll see what the effect of the difference. All right, okay. My goodness, seriously? The debt recovery one. Okay. Right. So I will just run through what these technical issues. Don't worry too much about it because these are part and parcel of what we'll have to face in this. Make your notes whilst I'm explaining these things, right? If I'm too fast, please do tell me. I wasn't looking at me, of course, for obvious reasons. I was looking at the messages. In a normal, in a did you all hear about the normal money recovery process about plain and answer and how it happens? Yes, right, good, fine. Then okay, then we came to the first part, right? Right. So the short title, yes, we spoke of this, right? Keep this in mind. Yeah, for the second time, right? Section Subsection 2 of section 1 was repealed, right? Repeal means it was deleted. Right? Subsection 1 stated, so it's intact, right? But subsection 2 was repealed. Subsection 1 says any lending institution or bank or whoever, and if they want to recover debt under the terms of this act, they will have to file that particular act in the district court. Now, what I was saying is, depending on the value of your money recovery case, if it's 5 million, 10 million, whatever, depending on the monetary value, we need to choose in which court that we are going to file the action. As the latest amendment of the High Court of Provision, Provincial Special Provisions Act, any commercial, any dispute or any suit
Sir,
during a commercial transaction, if the value of it is over 25 million, you have to file it in the commercial high court. If it is less than 25 million, only you can file it in the relevant district court. Right? But what is special about this act is irrespective of the amount. Right? If it's 5 million, 10 million, 25,
excuse me, sir.
50, 80 million, whatever, you cannot go to the commercial high court. You have to file that in the district court, the relevant district court. Right? Keep that in mind. That's one of those main provisions that is included in this particular law. Right? You can file it in that particular district court where if it comes within any one of these provisions, where the party defendant resides, if the cause of the defendant borrower resides, if the cause of action arises in that particular court, within the jurisdiction, within the power of that particular court, cause of action is, let's say, he defaulted in this, before the repayment of the loan in that particular area, in that court, or where the contract was sought to be enforced. If the contract was entered into the jurisdiction of the Colombo High Court, then you have to file action in the district court, like that. Right? Now you recall.
So excuse me.
No. Yes. Can you hear now? Can you all?
Yes.
Right. Okay, now I can hear you as well. See, if you I'm being lagging behind because I don't, what do you call, the screen on the messages is not away. What do you call, I can't see it all the time because I'm presenting. So if this issue persists, these are my numbers, drop me a text, then I know what something is wrong, right? Okay, cool, good. Right. So where were we? So this subsection 2 is now amended by the amending act. What does this amendment says? It says if the value of the case or what you are trying to recover is less than 150,000, you can't file action in this under this particular act. You can go under the normal procedure, plaint, answer, so on and so forth. Right? So one thing is you have to file in district court. Second thing is the sum amount that you are claiming is over 150,000. Right? Then under the amending act, we also saw section 4 is amended. Section 4 of the original act is amended. Sometimes I don't know whether you heard this, but you might seem that this is a bit dry, but then again, look at the importance of what I'm trying to convey here, because this is a marvelous piece of act. It's like 100, either you score 100 or 0. You have to have everything perfect. If not, there is a big issue in recovering your money. Right? So section 4 here, they say in the amending act, they have repealed or deleted subsection 1 of section 4, right? And substituted this new one under the amending act. This is what they are saying. Pay utmost attention to this. The institution or the bank suing shall not presenting the plaint. Remember plaint? In the normal procedure also there's a plaint. Here also plaint. But not only that, this goes further than that. File with the plaint and affidavit, diurum prakasha, to the effect that the sum claimed is lawfully due to the institution from the defendant. So that affidavit should say that that particular sum is lawfully due from the defendant to the bank. Then a draft decree nisi, right? Nisi ආඥාවේ කෙටුම්පතක්. Draft decree nisi. I will explain this, don't worry. Then the required number of stamps for decree nisi. There's under the stamp, what do you call it, in the Revenue Act, there's a stamp duty payable for this. So the amount of stamp duty either be paid or stamp should be compounded. The requisite stamps for the decree nisi. For service thereof and shall in addition. So in addition to that, file in court such number of copies as according to the number of copies of the plaint, affidavit, instrument. Instrument can be. For an example, you are suing the defendant on a check he gave which got returned. So that's the instrument here. So you have to attach that also. If it is part and parcel of your claim, you have to attach that. It's a must that you attach. Then agreement or document that you are suing upon, that particular agreement, loan agreement, whatever, that needs to be attached, right? And this number of decree nisi, right? The plaints should be as equal as in the number of defendants in the action. If it is one defendant, one set of those. Plaint, affidavit, instrument, agreement relied upon, and the stamps. Right, and the draft decree nisi. So that is one set. If there are 3 defendants, 3 of those sets. Right, fine. That's very important. Right. Then we go to the next important section. subsection 4 or section 4 is again deleted and replaced by this. Now, this particular affidavit which spoke of under subsection 1, that affidavit cannot be signed by anyone in the bank. It should be signed by a principal officer, a person who has responsibility and authority, having personal knowledge of the facts of the particular case. And such person shall in his affidavit swear or affirm දිවුරා හෝ ප්‍රතිඥා දෙනවා that he deposit from his own personal knowledge to the matters, right? So he has a personal liability there, right? Fine. Now we come to this area, that is section 5 of the original act is again amended by the amending act. What does the amending act says? It says that this particular decree nisi, you remember in the regular action, there was no such thing as decree nisi. What was there? They, instead of any decree nisi, they sent the plain with summons to file the answer. Here there are no summons to file answer. Here they send a decree nisi, right? And this decree nisi shall be subject to the provisions of 5B. And this decree nisi shall be ordinarily sent by registered post. How is it, sir? Ordinarily by registered post, right? If the defendant is a public officer, if he is, let's say, employed in a government department, right? The court, or at its discretion, in addition to sending the decree nisi by registered post, may also forward a copy of the decree nisi in duplicate, of course, by registered post to the head of that department where that particular defendant is working. And it shall be the duty, sorry, it's not only the defendant. If that is sent to the head of the department, the head of that particular department then gets a duty to cause that a copy of that decree nisi to be served personally by that head to the defendant who is his subordinate, right? And return a copy of the decree nisi to the court. This is the duty of the head of the department, to the court forthwith with either an acknowledgement of receipt of the decree nisi by the defendant or with a statement of service of decree. So he has to either, in that copy, has to mention either the defendant has acknowledged to have received, or he should make a statement and sign that I went and handed this over to him, right? If the defendant is not a public officer and employed in another another person, again the court may at its discretion forward a copy of the decree nisi in duplicate to the employer. And if the employer is a company, corporation, or whatever, and again a similar duty is casted upon that particular head of the department also, right? Now, they went on to, the law goes on to explain who is the head of a department. If it is used with reference to the member of any unit of the Sri Lanka Army, Navy, or Air Force, means the commanding officer of that particular unit, or the commander of army, right? If particular regiment, the commander of that particular, kind like that. If it's used with reference to a person employed in the provincial council, means the secretary of the provincial council. Employed in a provincial public service means the head of the department. Local authority, so municipal council means the municipal commission of the council. If it's an urban council or Pradesh Sabha, means the chairman of the council or Pradesh Sabha, right? If other public officer, department of that government in which such person is employed, so particular head of that particular department, right? Now, this give me a moment. Right. I'll come to the decree nisi part in a moment, right? Yeah, it seems like all of you can hear what I'm saying. Right. Right. Now, other matters, I'm not going to dwell much time on this, on proof of service, right? Yes, there should be sufficient proof of service of the decree nisi to the defendant, right? The act has gone far lengthier on proof of service because by this debt recovery act, keep in mind that certain rights or liberties of the defendants are made limited or curtailed, you can say. සීමා කරලා තියෙන්නේ නිදහස් අනිත් අයිතිවාසිකම් සාමාන්‍ය නඩුකරයක් හා සසඳනකොට, right? Because in a normal case, it's, I will explain that to you when I explain about the decree nisi and its effects, right? That's why the law has gone into greater detail on getting a confirmation, or rather ensuring that the defendant actually got the decree nisi, right? If it is sent through registered post, it shall be sufficient proof that the defendant got the decree nisi, right? If it is sent through the head of the department, acknowledgement of the head of department is sufficient proof. And if the court is satisfied that the decree nisi is sent to the defendant by registered post, but not advice of delivery has been obtained in respect there. So what this basically means is the decree nisi was sent, but sufficient confirmation of receiving that acknowledgement, or rather acknowledgement was not received by court. If that is the case, the court shall authorize the fiscal. Fiscal is an officer of court, right? Or any other officer authorized by court in that behalf to affix the decree nisi to some conspicuous part of the house in which the defendant ordinarily resides, right? සිංහලෙන් කියන පිස්කල් වරයාට අණ දෙනවා උසාවිය විසින් ඒ නයිසයි ආඥාවේ කෙටුම්පත හොඳ පෙනෙන ස්ථානයක මේ විත්තිකරු ජීවත් වෙන නිවසේ අල්ලන්න, right? Has to be pasted in a conspicuous part, or if it's a company, the usual place of the company. If that is done, then it will be deemed that the decree nisi has been duly served on the defendant. Where the court is satisfied that the decree nisi has been sent to the defendant by registered post, but no acknowledgement, or no acknowledgement by the head of the department, right? So this is what we just discussed. The fiscal will paste it, and the court will deem, once the fiscal paste it on the house, that it is being duly served, right? Right. So this again goes on the diligence that needs to be ensured when they are sending this decree nisi. Right. Then we go to the most important area under this debt recovery law, right? The process. Section 6 of the principal enactment. Subsection 1 is not amended. In an action instituted under this act, the defendant shall not. This is the most important thing under the debt recovery law. Section 6, subsection 1. You can make your notes down. In a regular action, once the plaintiff is sent with the summons, the defendant has the right to come to court and file answer. Here, in an action instituted under this act, the defendant does not have such a right, Or in other words, the law says the defendant shall not appear or show cause against the decree nisi unless he obtains leave from the court to appear and show cause. In a normal case, the defendant has to come and answer. සාමාන්‍ය නඩුකරයකදී විත්තිකරු උසාවියට පැමිණ උත්තරය ගොනු කළ යුතුයි. මෙහි විත්තිකරුට උත්තරය ගොනු කිරීමට අයිතිවාසිකමක් නැත. උත්තරයක් ගැන සඳහනකුත් නැත. මෙහි සඳහන් වන්නේ මේ පනත යටතේ නයිසයි ආඥාව විත්තිකරු වෙත බාර දීමෙන් අනතුරුව විත්තිකරු උසාවියේ අධිකරණයේ අවසරය නොමැතිව පෙනී සිටීමට හෝ එකී නයිසයි ආඥාව පිළිබඳව හේතු දැක්වීමට අයිතියක් නොමැති බව. I will explain that in Sinhala. In English again. Here, unless the court grants leave, permission, unless the court grants permission, here, unlike in the regular procedure, the defendant won't file answer. He will file, he will have to show cause. Hetu dakwanna ඕන. Against the decree nisi. What does decree nisi say? It's a draft order, right? On the face of the plaint and the affidavit, you remember, and the instruments and the agreement, the court, rather before going into the details, will issue a order to the defendant to pay this amount. Right? Or show the court why he should not pay that amount. Give reasons to court why he should not pay that amount. Right? Fine. The court shall, upon the application of the defendant, so defendant comes to court and doesn't file answer, he files an application to give leave to appear, permission to appear and show cause against the decree nisi. Either on these three instances, either the defendant paying into the court some mention in the decree nisi. So if it's the bank says in the bank it is 2 million defaulted by the this thing and file action under debt recovery act for 2 million, right? And the defendant will have to deposit either deposit 2 million in court, right? Or upon the defendant furnishing such security as to the court may appear reasonable and sufficient for satisfying the sum mentioned in the decree nisi in the event of it being made absolute. Or maybe deposit a bank guarantee to the amount of 2 million. Or upon affidavits satisfactory to court that there is an issue on a question in dispute which ought to be tried, the affidavit of the defendant shall deal specifically with the plaintiff's claim and state clearly and concisely what the defense is and what facts are relied on supporting it. Right? Affidavit here, the defendant, so either they should deposit 2 million or either they should deposit or something which will guarantee the court that that particular 2 million will be recovered, maybe like a bank guarantee. So third, file such affidavits and with such reasons by the defendant, specifying reasons why he should be given a chance to enter into permission to enter into this case and defend his action. Right? It should deal specifically with regard to plaintiff's claim. Right? specifically with regard to plaintiff's claim. Right. So if he doesn't do that, then the decree nisi will be made absolute. In simple words, decree nisi nisi tindu prakasha niyata tindu prakasha about a pakkar. So the draft decree nisi will be made absolute, meaning the judgment will be given against the defendant to pay that amount. So either one of these three instances, things should happen. Either he should deposit that 2 million, or he should deposit some sort of a guarantee that he will pay this 2 million, or he should show cause with an affidavit dealing specifically with the plaintiff's claim, bank's claim, that he has a reason, and the court has to hear his side of the story, because there's a valid reason why he should not deposit 2 million or he should not pay this 2 million. Understood? Right. So if he appears and leave to appear and show cause is given, then again, what will happen is court will lead evidence sometimes, if at the application of the party, and have an inquiry on this. It's not a trial, it's an inquiry on this, and what do you call, grant its order, right? Right. Then we go to other one. Now this is quite drastic, right? This particular section is inserted immediately after section 6 of principal enactment, and it's a new section, section 6A. No appeal by a defendant shall lie against the decree nisi, which has been made absolute under subsection 3, right, of section 6, on the ground of the defendant's non-appearance. So let's say you remember how the decree nisi was to be delivered to the defendant by the registered post, by the head of the department, conspicuous place, all these things. What this particular section says is, if the defendant gets to know later on that decree nisi has been made absolute against him, but he wasn't informed of this decree nisi, right? Maybe he didn't receive the registered post, maybe he wasn't living there, maybe for some reason. He cannot appeal against that order, but what he could do is he can file an application in the same court and ask for permission again. The court can give permission, right? Right. Then we go to right. Right. Level. If it appears to the court that the decree nisi entered by the bank in an action under this particular Debt Recovery Act was filed and was obtained by suppression of or non-disclosure of some material facts or relevant facts, right? After entering the decree nisi, the decree nisi is discharged and the action is dismissed. If under section 6, you remember section 6 A, B, and C, depositing the 2 million or depositing that particular maybe a guarantee or whatever to fulfill that, or the third limb, showing cause by affidavit and other means, why he should be given a chance to show cause and enter into this case. And the court decides by looking at those facts. Yes, what the defendant is saying is correct. Why did the bank did not disclose to this court that such and such thing has happened? These things were there. Maybe the state has suspended the recovery of these things by gazette notification, or the central bank has issued these circulars. Why did they do something? Why didn't the bank disclose those matters to court? If such a thing happens, the court will dismiss the action. And the court may, not only that, the court may, in the same action, on the application of the party against whom the decree nisi was entered, that is the defendant, award against the institution obtaining the same such sum as it deems reasonable compensation for the expense or injury caused to such party by the entering of the decree nisi. And an award under this subsection shall bar any action for compensation in respect of. So, not only dismiss the action, the court may also order the bank to pay compensation, right? Then we go to so far as you are concerned, section 16. Now, if leave to appeal, now if a decree nisi was made absolute, right, and the defendant makes an appeal or asks permission to appeal from the High Court and lodges that leave to appeal proceedings, the proceedings in the original court, that is the district court, shall not be stayed unless the Court of Appeal otherwise directs. And where the Court of Appeal so directs, it shall call upon the appellant. The appellant had been granted leave by the original court to appear and show cause under paragraph C of subsection 2 to give security or cash. So same thing applies. So if he prefers a leave to appeal, permission to appeal by the Court of Appeal, goes to the higher court against the decision of the district court, the effect of that decree nisi, I mean absolute, will remain the same. Unless the Court of Appeal says, no, hold on to it until I hear this appeal, right? Those are the main areas that you need to do, or you need to know with regard to Debt Recovery Act, right? And again, section. So before I go to the next two sections, any questions on this? No questions. Right. Then I'm going to take your attention to another more important sections under this Debt Recovery Act, where most of the people don't use. But nowadays I see a tendency of using this provision, right? That is section 25. And 26 of this law. Now you know about the provisions of the Bills of Exchange Ordinance. Now, Section 25 gives a strict liability. This is the only section in Sri Lanka which gives a criminal liability or a criminal liability. And it's not just a criminal liability, it's a strict liability. Here, what do I mean by strict liability? In strict liability, in a normal criminal liability, you have to prove two things. One is the action, and the second thing is intention to do that action, criminal action. Under strict liability, the action itself is enough. It will only be applicable if the law specifically says that. So here, it is a criminal liability, but the intention need not be proved. If the action itself is there, that's a criminal liability, right? What is that? Any person who draws a check knowing that there are no funds or not sufficient funds in the bank to honor such check, or makes an order to a banker to pay a sum of money which payment is not made by reason of there being no obligation on such banker to make payment or by reason of the payment having been countermanded, right? One thing is you, for example, in simple words, somebody draws the check and give it to somebody else. There is no balance in the account. Check is to the value of 2 million. He knows that the check is going to bounce or return. That is the first one. Second one is he gives a check, right? So that's a order to the bank to pay that amount, which payment is of money to pay someone, which payment is not made by reason of there being no obligation on such banker. So what would be the causes of no obligation to the banker to pay that check? Maybe the check is drawn wrong, or by reason of payment having been countermanded. So if somebody draws the check and countermands payment to the bank for no reason, no valid reason, right? It's a criminal act, right? It's a criminal act. Or gives an authority to an institution to pay a sum of money to itself, a payment of debt or a loan or any part thereof owed to such institution from and out of an account maintained or funds deposited by such person with such institution, and such institution are unable to make such payment to itself by reason of such person not placing adequate funds in such account, or by reason of the funds deposited having been withdrawn by reason of such person countermanding the authority given, or by reason of any of one of more such reasons, right? All these are criminal acts, right? Having accepted bill dishonors it by non-payment shall be guilty of an offence under this act, and shall on conviction by a magistrate after summary trial be liable to be punishment with imprisonment of either description. What is either description? Simple or rigorous imprisonment. සුළු හෝ බරපතල වැඩ සහිත දඬුවම්. Imprisonment of either description for a term which may extend to 1 year. අසරක් දක්වා දීර්ඝ කළ හැකි. With fine of 10,000 rupees or 10% of the full value of the check, order, authority or inland bill. Right? So everything comes into this. Remember, that is a strict liability provision. This, not only that, by the amending act, it has included companies also, right? If that act is done by a body of persons, it's a body corporate, every director, manager or secretary of that body corporate, right? If it's a firm, every partner, if it's a unincorporated body, every individual of that body is guilty of that offense, right? Then right. So those are the provisions that I have to wanted to cover with regard to Debt Recovery Act. Any questions on Debt Recovery Act? This is a main area on your exams as well. So, any part that you didn't understand, or any other question that you want to ask from me with regard to Act number 2 of 1990 as amended by Act number 9 of 1994. No. It seems that I will also inform the institute that we should be able to conclude the lectures insofar as I'm concerned today. We have covered the Debt Recovery Act. We will cover the Recoveries of Loans by Banks Special Provisions Act. Then my deed is done, and there may be one day more for you to conclude the lectures. Right? So, no questions, I assume. Right. Fine. Now we go to, we will cover another important area. Recoveries of Loans by Banks Special Provisions Act number 4 of 1990. Yeah, I will do that. I will send it to the institution, then they will do the needful. This is also called Parat Act on Parat Execution in layman terms, right? Again, this act has been amended for a couple of times now. Latest being Act number 19 of 2011. Before that, Act number 1 of 2011. And before that, there was a minor amendment, very minor one. That is by I'll mention that in a moment. Right. So we will see what this Recoveries of Loans by Banks Special Provisions Act. I'll pull this up. Oh, can't see. Right? Parat is a Latin term, right? Now, you know by now, which we discussed up to now, the normal money recovery process and the debt recovery process. And when I say debt recovery process, all are debt recovery, but when we now that we know debt recovery, when you hear the term debt recovery, it's under the Debt Recovery Act, right? Number 2 of 1990. Now, all this, the common thing what the bank had to do is the bank had to go to courts, right, for all this time. But this Act number 4 of 1990 went a step further. What was that step? This Act number 4 gave the power to the banks, all licensed commercial banks. Right? Before the People's Bank and Bank of Ceylon, on their own People's Bank Act and the Bank of Ceylon's Ordinance had this power But this was extended, this power was Parat execution was extended to all licensed commercial banks by Act number 4 of 1990. So what is Parat execution? It's a procedure that enables the bank to sell mortgaged property. Own a property එකක් නෙමෙයි. Mortgaged property. Movable or immovable. චංචල හෝ නිශ්චල ජයපල. උකස් කර ඇති. To recover defaulted advances without filing actions in a court of law. This is big. They don't need to go to court to recover that amount. Only if there is a mortgage. But there is a rigorous, procedure that they have to follow. So they don't go to courts. They don't say, they send letters of demand and all, but nothing. They don't go, and we call it a hypothetical reaction. Ukas kara nadu pawaranda and avasya. Right? But there is a process. Right? It's applicable to all licensed commercial banks and licensed specialized banks. Right? Executing Parat rights under recovery under this act, board of directors of the bank should pass a resolution to acquire the mortgage property instead of the default. After acquiring that, the certificate of sale will be executed in the name of the bank, and the bank will auction the property to recover the outstanding balances. So, who are the parties involved in Parat execution? I'll share this with you. I think this has already been shared with you all. Right? The borrower, the customer. Lender, who is the lender? The bank. Mortgager. Mortgagor, actually, it should be mortgagor, G-O-R. Mortgagor. It's the person who is mortgaging the property. It could be either the borrower or any other party. Mortgagor. Ukas karu. Mortgagee is the bank. Ukas himi. Right? Keep this in mind. This is not a it's not a court procedure. This is not a court procedure. This is we call it a extrajudicial procedure. Right? Extrajudicial procedure. We will see what this act says. Marvelous act. And there were so many cases, and there are so many cases, and there will be so many cases. Right? So the first thing is, when there is a default, the bank will be sending normally a letter of demand. Letter of demand is sent, there is no response from the customer, or rather, the customer doesn't, pay up. Right? Pay up. I'm trying to put the and the other one is Act number 24 of 1995. That is the other, but it was a very minor amendment. Right. I'm going to go through these sections with you, the main sections. Keep this in mind, very important, right? We'll have to pull that up one second. Right. We'll have to go one by one, right? See whether there is a PDF version. Right. So, this is an extrajudicial remedy. Every person to whom any loan is granted by a bank on the mortgage of property. So, mortgage is a must. Mortgage bond. Who has obtained probate of the will or letters of administration to the estate of a person to whom any loan has been granted by a bank on the mortgage of the property. Right? So, either the borrower or his heirs. මොනවාද ණය කරු ඔහු මිය දුනාට පස්සේ ඔහුගේ උරුමක් කරුවන් හරි ඔහුගේ බූදලෙන් අය කරගන්න පුළුවන් upon application made in that behalf by the board මොනවාද board කියන්නේ what is the board the director board of the bank has been appointed by court to represent such as mortgage who upon application made in that behalf by the board has been appointed by the court to represent such estate. So basically think about the heirs of the borrower or to whom any right, title or interest whatsoever in any property mortgaged to a bank as security for any loan has passed, right, whether by voluntary conveyance or by operation of law shall register with the bank and address to which all notices to him may be addressed, right? So what does this speaks of? This speaks of the borrower of the loan to whom any loan is granted. So the borrower, it speaks of the borrower, right? He shall register with the bank an address to which all notices to him, right. Notices to him may be addressed. So when the bank is granting the loan, the upon signing of a mortgage bond, that particular borrower will register with the bank or the address to which all notices pertaining to that loan should be sent to. So borrower is there. If he is dead, his heirs, right, or any other person, the right and title of that property is passed by voluntary conveyance, either deed of transfer or gift, or by operation of law shall register with the bank, right? Basically the borrower. Any notice which is required to be served on any person to whom this subsection applies shall be deemed to have been duly served on that person if it is sent by posting a registered letter. Remember something similar to the debt recovery. So whatever the law deems that, whatever the notice that has to be sent to that particular person, as mentioned in subsection 1, will deem to be served if it is registered, posted to the given address, right? Right. Provided that where any such person fails to register, in the event if such person fails to register anything of the address like that, that service of certain notices those notices will be deemed to have duly served if those notices are published in the Gazette, in at least in the Gazette and in at least 3 daily newspapers in Sinhala, Tamil, and English, and notice addressed to him, and such notice shall be deemed to be duly given to him. Remember till that point, huh? That point. Right. Yeah, I see. Right. Then, still we didn't come to this point too. Huh? Now we are coming. Action by the board. This board is the director board of the bank. Whenever default is made in the payment of any sum due on any loan, whether on account of principal or of interest or of both. So default is made on principal, either on interest or on both. Default shall be deemed to have been made in respect of the whole of the unpaid portion of the loan, and the interest due thereon up to date, and the board may in its discretion take action as specified in next two sections 4 and 5, right? So if the borrower or mentioned in, default is made on the loan, right, either on the principal or interest or both, it shall be deemed that the loan is defaulted on the unpaid portion of the loan, right? The board may, in its discretion, take action as specified in section 4 and 5. However, if the board in any case take action or commits to take action in accordance with section 5, we'll see what section 5 is. Nothing shall be deemed to prevent the board at any time from subsequently take any action in that case by resolution and section 4 of the board, if the board deems it's advisable to do so. So just because the board decided to take action under section 5 doesn't mean the board can't take action under section 4. They can do that also. So we'll see what section 4 says, right? We'll see what section 4 says. Subject to the provisions of section 7. So there are certain conditions mentioned in section 7. Subject to that, the board of directors may by resolution to be recorded, a board resolution, right? In writing, not willing, in writing, authorize any person specified in the resolution to sell by public auction any property mortgaged to the bank as security for any loan in respect of which default has been made in order to recover. Now you know what is a default. In order to recover the whole of the unpaid portion of such loan and the interest due thereon up to the date of the sale, together with the monies and costs recoverable. So section 4 basically is passing a resolution authorizing a party to sell the property by, so the decision to sell the property by public auction, right? Section 5 says, again, subject to the conditions in section 7, the director board may by resolution to be recorded in writing authorize the person specified in the resolution to enter into upon, right, any immovable property mortgaged to the bank as security for any loan in respect of which default has been made, right, where the terms of any loan agreement are contrary. So basically they have defaulted on the loans, right, to take control of the management of that property, right, if such property as might have been exercised by the mortgagor, if he had not made default or contravened the terms of such agreement, right? So bank can, under section 5, section 4 authorized or resolved to sell the property by public auction. Or under section 5, resolved to enter into that property and manage that property as the mortgagor used to manage the property. Why is that? To generate income. If that income the borrower didn't pay by mortgaging that, so that property, and didn't repay to the bank can go into the shoes of the mortgagor and generate income. Where any sum of money due on any loan granted for any agricultural or industrial undertaking on the security of plant machinery, right? The board may authorize any person specified in writing to enter into and take possession of such agricultural or industrial to say similar thing like subsection 1 and 2, right? Then, by Act number 1 of 2011, they did something like this. Now, 5, you can see 6 here. They introduced section 5A by Act number 1 of 2011. What did they do there? Right? Give me a moment. Right. What did they do there? They say no action shall be initiated in terms of section 3. Monada section 3. What is section 3 says? Action by the board where default is made. Board may take action under section 504. Right? On account of principal, interest or both. Right? Recovery of any loan in respect of which default is made, right? Nor shall any steps be taken in terms of 4 or 5, where the amount of such loan is less than rupees 5 million. You may note these things now. No Parat action can be proceeded with if the loan amount is less than 5 million, right? It says, provided, however, at the time of default, when calculating the amount due and owing to the bank on the loan, granted to such default, the interest accrued on such loan and any penalty imposed thereof shall not be taken into consideration. So, when they are deciding that the default is made, section 3 says default on principal, interest or both, then it triggers. But this says, despite it says something like that, if the loan amount is less than 5 million, even if there is a default, you can't go with Parat action. At the time of default, when calculating the amount due and owing to the bank, that is what? To check whether it's over 5 million or less than 5 million on the loan granted to such default. The interest accrued on such loan and any penalty cannot be taken into consideration. Right? Right. Then, section Act number 19 of 2011 again amended. I remember very well when they amended this. Right? It elaborates or amended section 5A or the previous amending act. And it said, now section 5A is amended by substitution to the word. So they basically replace the word amount and replace it with the words principal amount. So now this you have to read like this. No action shall be initiated in terms of section 3 of the principal enactment, recovery of any loans. No any steps shall be taken under 4 and 5, where the principal amount of such loan is less than rupees 5 million. Right? Principal amount. Provided, however, at the time of default, when calculating the principal amount due and owing to the bank on the loan granted to such default, the interest accrued on such loan and any penalty. So, principal amount. What does principal amount means? The principal amount without the interest and penalties. Now there is a question. What do you mean by principal amount? Borrower borrowed 6 million, right? And is that the principal amount? The borrower borrowed 6 million, and after a year, now the principal amount outstanding after repayment is, let's say, 4 million. Is that the principal amount? So this question came up to decide, right? In the case of Sumudunanakar versus Hatton National Bank, SC Appeal 53 of 2017. Right? Sumudu Sanjeevani Nanayakar. SC Appeal. The court held that, right? Court held that so this is the position after the amending act number 19 of 2011. Right? The court now then analyzed amount has been changed to the principal amount borrowed. Right? And then the court said that the amounts were, what is meant by the phrase principal amount borrowed due and owing to the bank? It means the balance of the principal amount borrowed, not the original one. In other words, it means the balance of the original amount of the loan granted to the borrower. Right? Because this is the reason, very nicely analyzed. If the argument that the property mortgage to the bank of a person who did not pay any amount on a loan of 4.9 million cannot be sold by the bank in public auction, but the property for a person whose balance is only 0.1 million on a loan of 10 million can be sold by public auction because he had taken a loan of more than 5 million. This means bigger defaulters property is protected, but not the small defaulters property. That is the case, right? So, who did not pay any amount of 4.9 million? One party, let's say he took 4.9 million loan, which is less than 5 million, right? He did not pay anything. The bank, if that is the case, bank cannot take public, cannot Parat execute it. But person whose balance is only 0.1 million on a loan of 10 million, right, can be sold by bank in public auction. So it is not the original principal amount, it's the principal amount outstanding, right? So keep that in mind, and this particular case, very important. This is decided in 2017, right? I'm losing my voice now. Right. Any person authorized by resolution of the board under section 5 in respect of any property shall be entitled generally to take action in terms of the resolution, and in particular to sell the produce of such property, to sell the goods manufactured by the property, receive the rents, pay expenses, to appropriate to himself out of such income, etc., etc. Right? Then we go to section 7, where the borrower is dead. Right? Where the borrower is dead. Right? even when there is a default, notwithstanding the borrower may have died or that any right or title, interest whatsoever in the property mortgaged to the bank as security for the loan may have passed by the voluntary conveyance operation to any other person. Right? So, despite the borrower has died, you remember what we mentioned in section 2. Right? If he has died, it goes to the heirs. Even if it goes to the heirs, the effect of section 4 is there. Bank can resolve to sell the property. Right? Then we go to section 8. Important areas for a reason I'm telling because I'm going to give some other case laws. Notice of every resolution under section 4 authorizing the sale of any property shall be published in the Gazette and in at least 3 daily newspapers in Sinhala, Tamil, English, and shall be dispatched to the borrower if he is alive and to every person who has in respect to that person registered in his address. So you remember the resolution passed under section 4, right? So notice of that resolution, it says, should be published in the Gazette and in at least 3 daily newspapers in Sinhala, Tamil and English, right? And should be sent to the borrower. So that is giving notice that this is going to be sold in public auction, right? Right. Right. Then notice of notice of every resolution under section 4 shall be dispatched to the borrower. Shall be dispatched to the borrower. Not to the mortgagor. This is not what it says. It says it shall be dispatched to the borrower. The notice of sale. Notice of the date, time and place, section 9. Notice of date, place of and every sale authorized by a resolution under section 4 shall not less than 14 days before the date fixed for the sale be published in the Gazette and copies of such notice dispatched to the borrower. So Diana, you will see 2 notices has to be done. One thing is the notice of the resolution under section 4. It should be published in the Gazette, published in 3 languages, Sinhala, English and Tamil newspapers, daily newspapers, and it should be sent to the borrower. That's section 8. Then section 9 says, that is on the fact of the resolution that the bank has decided to sell it by public auction. Then second notice is given under section 9, that is the date of sale by public auction. That also should be gazetted, 3 daily newspapers in 3 languages, and notice should be sent to the borrower. Right, sent to the borrower. If the payment is made before the sale, right? If the amount of the whole of the unpaid portion of the loan, together with interest payable and recovered by the board under section 13 is tendered, the board at any time before the sale, the property shall not be sold. Right? Now, it's like this. If the whole of the loan, unpaid portion of the loan is paid before the auction, board cannot sell it by public auction. If the defaulted portion of the loan installment is paid, the board has a discretion whether to go to public auction and pay it or not. Right? Then there's a discretion. Then something the bankers use and something which is used quite commonly, and although people don't have any idea what this is called the upset price. What is upset price? Upset price is where the board can fix a price below which the property shall not be sold to any person other than the bank to which the property is mortgaged. So normally upset price is calculated like this. Let's say there is a 10 million loan, 7 million outstanding, 7 million on principal outstanding. And let's say 500, another 300, and it adds up to about another 500,000 interest plus penalties and bank charges. So altogether, 7.5 million is due and payable by the borrower to the bank. So, and then the auction charges to this and all other charges, let's say, comes to around 7.6 million. That is the upset price. So below that price, the bank will not sell it to any other party by public auction other than to the bank, right? What do you mean by other than to the bank? Below that price, the bank can, if there are other parties, if there are no bidders to that property over that upset price, the bank will not or shall not pay, sell it to any other party, third party below the upset price, other than to the bank. So normally what happens is the bank will purchase the property if there are no bidders at the auction. The bank will purchase the property for a nominal amount like 100 rupees or 1000 rupees, right? Then section 12 says, in any case where two or more loans have been granted by a bank on security of the same property, right? So there are a couple of loans mortgaged by one property, right? Default made in the payment of any sum due upon any one or any of such loans. So let's say there are 3 loans. Out of 3 loans, one got defaulted and the other 2 are performing. The bank can treat all 3 as defaulted and go for Parat, right? So bank can, by resolution under section 4, you remember section 4 resolution, authorize the sale of the property for the recovery of the total amount due to the bank in respect of both or all the loans, right? Right. So bank can recover the expenses, etc., and there will be a certificate of sale. Now, once the property is sold at the public auction, the board shall issue a certificate of sale, and thereupon all the right, title, and interest of the borrower will go to that particular purchaser. Right? Certificate of sale shall be signed by the board of directors. Right? It should be conclusive proof that the sale of that property is made. And that certificate of sale is subject to payment of stamp duty. Now, there are some important judgments with related to recoveries of loans by banks. What are these? Now you remember I told you that now, so passing a notice of resolution, this is what we said: upset price, auction, condition of sale, certificate of sale. Now, this, let's say, third party mortgages. Now, for all this time, we were thinking those parties which I mentioned, right, earlier. The borrower, mortgagor, mortgagee, which is the bank, right? Again, the lender is the bank. So most of the time, borrower and mortgage are the same. But there can be an instance where the bank is paying money to one party, the borrower, on the mortgage of property by another party. So then the borrower and the mortgagor are 2 different parties. In the case of Ramachandran versus Hatton National Bank, I'll give you the case references. Chellaya Ramachandran versus Hatton National Bank. right? The court held that the bank cannot go for Parat execution if it's a third party's mortgage property. If the property mortgage is not of the borrowers, but if it is a property of a third party, the bank cannot go for Parat execution, right? This is the case reference I will give you. So there were actually 4 cases. The courts combined all 4 cases and decided as one case. One case is Chellaya Ramachandran and another versus Hatton National Bank. Second one is Anand Siva versus Hatton National Bank. Then Ukwat versus DFCC Bank. MD Karnavati versus DFCC Bank. In this case, wonderful, remarkable, spectacular judgment, where Chief Justice then Sarat N. Silva said, you cannot go for Parat execution on a mortgage property where the property mortgage is of a third party and not of the borrower. I will share you the references. These are the references of this particular case, right? Right. Then in 2008, in the case of HNB versus Javardhana, 2008, 1 SLR 181, that is the reference. Court modified a little bit of what Ramachandran versus Hatton National Bank's judgment of third-party mortgages. So HNB versus Samatapala Javardhan, right? What did court say here? Court said, yes, the Chief Justice Sarat N. Silva's judgment is valid. Third-party mortgages cannot be taken for Parat execution. However, if the third parties if the borrower is the company and the mortgagor are the director shareholders of the company, right? The borrower is the company. Mortgagors are, or the property is owned by the director/shareholder of the company. Then, although the company has under the company law, a private limited company has a distinct legal personality, the law will lift that veil of cooperation and say, company here being the borrower, mortgagors being the shareholder directors are not two persons, but they will be considered as one and the same persons. In other terms, the court held that the director shareholders' alter ego or company's alter ego is the director shareholders, right? Therefore, in such a situation, you can go and Parat execute the property, despite the fact that borrower is the private limited company and the mortgagor are the director shareholders, right? Right. So, then there is this legal principle called liceo inomis, right? It's a Roman Dutch law principle. That means if the seller or purchase of a property has been prejudiced in the price to the extent of more than half of the real value, even though no fraud has been perpetrated on either side, the parties of prejudice may give the other the option of either cancelling the sale or of increasing or reducing the price in accordance with the real value, right? But basically, happens is this was considered in the case of HNB versus Javadana, Samatapal Javadana 2007, and Javadana versus Sampath Bank, where the bank sold to itself a property at a public auction Parat under this act. Such sale cannot be challenged on the basis of the principle of liceo enormis, because bank may purchase the property below the upset price, maybe like I told you about 100 rupees or 1000 rupees. So bank purchasing the property for 1000 rupees, which is a property value maybe 10 million, you cannot apply the principle of liceo enormis. What liceo enormis means is, let's say one party sold the property knowingly or unknowingly to another party, let's say a property worth of 10 million, he sold it to 3 million. Then principle of liceo enormis comes and the seller can give the option to the buyer either to cancel the sale or pay up the balance 7 million. That's liceo enormis. But this particular case stated that it will not be applicable for purchasing the property by the bank itself at a nominal value which is less than the upset price. Right? Right. So that's about recoveries of loans by Bank Special Provisions Act. And that's about the lecture series that I will be conducting. We have reached the time as well. Do you have any questions to ask before I conclude?